Joining us now is Democratic Senator Sheldon Whitehouse of Rhode Island. He's a member of the Senate Judiciary Committee and chaired a subcommittee hearing today on ethics and accountability on the Supreme Court. Senator Whitehouse,
timing, huh?
Yeah, let me see if I understand where we are right now on ethics at the Supreme Court. Chief Justice confirmed today that the leaked document is an authentic draft opinion. The Chief Justice then announced an investigation by the Marshal of the Supreme Court, an investigation of the leak. And the Chief Justice remains absolutely silent about the possible investigation of Clarence Thomas ruling on cases involving his wife's communication with the White House. Do I have it straight that the ethics of the Supreme Court tonight do not include any consideration whatsoever about Clarence Thomas ruling on cases involving his wife's communication, but they are worried about the leak?
The Supreme Court justices are the only federal judges in the entire system who are not subject to the code of ethics. They hold themselves above it, and they believe that each can be judge in his or her own cause of their own ethics. And at the same time, they have ethics rules, again, optional. They're the judge of whether they're meeting that standard or not, but the rules themselves are weaker than those for equivalent positions in the executive branch and equivalent positions in the legislative branch. So the rules are weaker for the Supreme Court than for equivalent positions in the other branches, and they don't hold themselves even to those low standards. So the hearing today revealed, I think, a pretty rotten ethics mess over at the Supreme Court that affects a whole variety of ways in which the court operates, and recusal is right smack dab in the center of that.
How about the ethics mess that is on display in Supreme Court confirmation hearings when Republican nominees are asked about Roe versus Wade?
Yeah, that's really become performance theater, and it's getting a little bit sickening because they all come in and they all say the same solemn statements about how much they care about precedent and how serious they are about stare decisis. And then they go out and say completely other things afterwards. Justice Kavanaugh said, well, you know, I'll accept precedent unless I think it's seriously wrong. Didn't say that in his hearing. Justice Roberts said, well, I'll accept precedent unless it's hotly contested. Didn't say that in his hearing. Thomas has said he'll accept precedent, but only if it's not demonstrably erroneous in his own personal view. He didn't say that in his hearing. And the worst of all was Alito, who wrote this opinion, who made the usual statements about stare decisis, about precedent. And then he said to a laughing Federalist Society audience that stare decisis means to leave things decided when it suits our purposes. He made it a laugh line. So it clearly shows that they treat the Senate confirmation process as just a show to get through, to be able to deliver for the big donors who put them there at the end of the day, and they discard what they said in the hearings. It is infuriating.
And there's no hint in this opinion that these judges are just now finding Roe versus Wade egregiously wrong. If it's as egregiously wrong as they say, then that was apparent to them in law school, in the case of Clarence Thomas, and all of the others in law school.
And apparent to them in their nomination hearings in the Judiciary Committee, and apparent to them in earlier decisions that they wrote for the court where they didn't spark off like this. I mean, I think people around the country are justifiably extremely upset and frightened by what this court has done. And part of it is because none of them laid the foundation for this in their public judicial confirmation hearings. They all solemnly said, oh, Roe v. Wade, very important, settled precedent. And they went out of their way to create the impression that they would honor it. And then, of course, that was phony. That was just part of the show to get on the court and then do what the big donors want.
And when you look at the opinion compared to the words that Robert Bork actually said in the Judiciary Committee in 1987, it is essentially the Robert Bork view of Roe versus Wade turned into a fully written first draft Supreme Court opinion. And that
he lives again.
That thinking has been
available.
available
has come
to
out of the grave and lives and walks the earth again.
But I mean, I submit that as an indication that these justices thought this for a very long time. They thought it since they heard that lecture, in effect, by Robert Bork in the Judiciary Committee, if not before.
There's no reason whatsoever to believe that this was some recent epiphany by all of them. I think they've been strategically keeping their intention to undo Roe versus Wade as secret as they could, until they knew they had the votes and could do the secret handshake, and then go out and do their worst.
Senator Sheldon Whitehouse, thank you very much for joining us tonight. We really appreciate it.
Good to be with you.
Thank you.